Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today is the day I earned that subscription. For today's story, we are picking up the story with Donald Trump, who is being investigated for various crimes against the United States, including potentially classification issues under the Espionage Act. And there was a stay put in place by the district court that prevented the government from using any of the evidence collected, while an independent adjudicator, that's called a special master, had an opportunity to review the information, because some of the information might be legally protected, for example, by attorney-client privilege. And so there might be a need for someone to take a look at it before the government could use it and say, hey, government, you can't use this information you seize because it's protected by things such as, for example, attorney-client privilege. But the government had a complaint. They said this doesn't make sense with respect to material that is stamped or marked classified. It can't be his personal material because, stamped or marked classified. It's governmental material, and we should be able to use it in a potential criminal investigation, including by, for example, using it for presentation to a grand jury, who might then be in a position to bring various charges for offenses against the United States. So this issue was brought to appeal before the 11th Circuit Court of Appeals, which is the federal appeal court that oversees Florida, where the trial court is based. And the appeal court has indeed granted the government's request with respect to the material marked classified. We will discuss this, of course, in more detail, but I will make one point of note before we get into the decision itself. To say that it is marked classified is not necessarily to say that it is classified, but it is prima facie evidence of classification, right? The classification markings themselves are not secret, so you or I could, of course, just take a document and just put classification markings on them. That doesn't mean that they are classified, even though they're marked classified. But, of course, a person coming upon such a document and seeing classification markings would have to treat them as classified, even though they may or may not be classified. Of course, in Donald Trump's case, it may or may not be classified because Donald Trump may or may not have declassified the information, but nevertheless didn't go through a formalized process. So the material on first inspection would appear to be classified because since it didn't go through the formalized process, the markings weren't changed. But whether or not they are classified or not is not yet established, but they appear to be. All right. So with that minor point of clarification or distinction, let us pick up with the 11th Circuit Court of Appeals in the case of Donald Trump versus United States of America. All right. And we will read this decision by the 3-member Court of Appeals decision. This is per curam, which means it has no listed author. Following the execution of a search warrant at the residence of Donald Trump has moved for the appointment of a special master, which is just the name for the neutral referee, right, to review these documents that the United States has seized. The district court granted that motion in substantial part. Now the United States moves for a partial stay of the district court's order as it relates to roughly 100 documents bearing classification markings. So there were something like 11,000 documents taken in total, but about 100 of them have classification markings. Okay. We need to decide only the narrow question presented, whether the United States has established that it's entitled to a stay of the district court's order to the extent that it requires the government to submit for the special master's review documents with classification markings. So issue number 1, the special master would have to see and review the classified documents, which itself could be an issue because the special master necessarily doesn't have specific clearance with respect to the particular documents. And now, of course, they can be given it, but that's a potential issue, right? The special master would see the classified information, and they may not be necessarily a person who otherwise would see them, so that presents some potential issues. Of course, the special master in this case, it should be pointed out, is a retired judge who is still sitting on the bench not retired, that's the wrong phrase, senior judge, that's the one I wanted. They are a partially retired judge So they are a current sitting federal judge and also a federal judge. Well, they're partially sitting in so much as they're working part-time. It's complicated. They're not taking up a formalized seat. It's within the rules of the U.S. law, right? So they're a part-time federal judge, and they hear cases from time to time as needed, but their seat can be taken over by someone else. And also, as by virtue of this, by virtue of them being a federal judge, they also happen to have served time on the FISA court. So they have some particular experience with classified information. So if you're looking for someone to review the classified information, a currently sitting senior quasi-partially retired federal judge who has served on the FISA court and therefore reviewed much classified information would be a good choice. Anyways, this person would review this information, and it would enjoin the United States from using that documents in a potential criminal investigation. So can the government please not submit this to the special master, and can it please submit it, for example, to a grand jury, which also incidentally is not within the classification scheme, but that's the nature of prosecuting these cases, right? We might have to present the information to a grand jury, maybe. All right, and to a jury eventually, maybe, all right, what the classified information is. We stress the limited nature of our review. All right, we did that. For reasons below, we grant the United States motion. So we know the spoiler alert. They're going to say yes. These 100 documents that are marked as classified, as distinct from the 11,000 documents we took, right? These 100 you can use now without any further review by the special master. Okay, great. Let's read that. The plaintiff left the White House in January 2021 after serving President of the United States. It is nice for the court to acknowledge that, he was at one time the President of the United States, because it seems that some people want to not acknowledge that. Upon leaving office, Movers transferred boxes of documents to his personal residence in southern Florida. The record reveals that throughout 2021, and consistent with responsibilities of the Presidential Records Act, the National Archives sought to obtain records in his possession. In response to these requests, plaintiff transmitted 15 boxes of documents to the National Archives. The National Archives reviewed the contents of the boxes they were sent and found inside those boxes newspapers, magazines, printed news articles, photos, miscellaneous printouts, notes, but also presidential correspondence, personal and post-presidential records, and a lot of classified records, at least according to the affidavit for the search warrant. So he sends them classified documents. Why do you have these documents to send to us? Is potentially a note of concern. Consequently, the National Archives sent a referral to the Department of Justice. Upon learning about the classified materials, the department sought access to the boxes so the FBI and others in the intelligence community could examine them. The National Archives responded by advising the president in April that it intended to provide the FBI access to the records. When the president requested an extension, the National Archives held off on sending the documents. On that date, Donald Trump asked for another extension and informed the National Archives that if it declined to grant, he would make a protective assertion of executive privilege over the documents. So one of the things he's going to say is, okay, FBI, you cannot review these documents because they're protected by executive privilege. And then we get into super fun questions about if it's possible for a former president to claim executive privilege vis-a-vis the current executive, right? The FBI is part of the Department of Justice, and the Department of Justice is part of the executive branch. So claiming executive privilege gets a little bit weird, if it's possible at all, because all privileges by their nature belong to someone, right? The term executive privilege tells you who the privilege belongs to. The executive, right? Just so much as you would say attorney-client privilege, who does the privilege belong to? The clients, right? Doctor-patient, who does the privilege belong to? The patient, right? It's right there sort of in the name. So does the President of the United States enjoy executive privilege? Well, yes. As it relates to other branches of government, sure. This is one of the things that allows the executive to not give information to, example, the judicial branch or the legislative branch, right? Because it would interfere with core executive functions. And so then you get into those wonderful fights about whether Congress can or cannot get access to particular materials, and those fights never stop. But here is not the current executive saying we're not going to give information to legislative. It's the past executive saying we're not going to allow the current executive to review materials because they're privileged under executive privilege, which means it's the executive privilege that belongs to the executive, which at this point is Biden. But you can't review them because the privilege belongs somehow to the ex-president. You can see under constitutional grounds why this is questionable. The Supreme Court has never spoken strictly to the point, but has, at least in its documents, or at least in its rulings, has alluded to the possibility that maybe it's possible, under some circumstances, the executive retains some sort of privilege that would persist to new administrations. But whether it does or not is a decision for another day. One would imagine this court decision may, at least in part, decide that eventually. Okay, that's what's going on. He says executive privilege. The executive can't look at the privileged documents that are protected by executive privilege, which belongs to the executive. Okay, fine. The letter notes that President Biden had deferred to the National Archives the determination that executive privilege did not apply. So is it privileged by the executive? Well, one of the ways you could determine that is by asking the executive, right? One of the ways you could determine, for example, if attorney-client privilege exists is by asking the client. If the client says nah, then, okay, well, they asked the executive. Biden said nah. So, okay, you got that going for you. Despite advance warning, the plaintiff made no effort to block FBI access to the documents at that time. During a preliminary review of the documents, the FBI found 184 documents marked at varying levels of classification, including 25 documents marked as top secret. Again, we will make a point of noting that just because they are marked top secret doesn't mean that they are top secret, but of course, it doesn't mean that they're not either, because everything gets weird when it comes to the president, right? The normal way you go about classifying and declassifying things is, of course, specified by executive order. But the executive order is an order from the executive, that is, the president, to the rest of the executive branch, which means, of course, the president doesn't have to follow it because it's an order from the president. So the president isn't bound by executive orders. So anyone else in the executive would have to follow the process brought out by the executive order, but not the president. So one thing we can say, I think definitively, is that President Trump did not follow the process set out in the executive order for the declassification materials. But he doesn't necessarily have to, because the executive order was an order from him. So, yeah, good times. Someone asked, don't I mean ex-president? It depends on various frames of reference of time, right? And so this is one of the tricky things. We have to remember about time frames, right? So the question, of course, would be whether President Trump declassified the material while he was president. Any authority he had to classify or declassify material necessarily evaporated when he stopped being president. So when I say president, okay, first of all, so this is where language gets tricky. First of all, it is not uncommon in the United States to refer to an old office holder by the term president. You can call them ex-president, obviously, but it's not necessary, nor is it necessarily even common. You'll hear someone say President Carter, President Bush, President Obama, right? Even though obviously they're not president anymore, you still call them by their old title. It's a courtesy, right? They're obviously not president. So me calling them President Trump is not uncommon. Obviously, he's not president now, but it's just a courtesy, so you have to roll. And then, of course, we have to determine if he did certain things while he was president. So depending on my frame of reference, you'll have to deduce whether I mean president in the sense that he was president or he did things while he was president. It gets confusing, but we'll manage together. The FBI, my bias is showing. I hope not. I mean, I'm not biased. I'm just telling you the reality. Presidents are referred to by their title, and presidents obviously have power that it is beyond what the I don't know how to be less biased than that. I think that's pretty neutral. Obviously, whatever power President Trump would have had to classify and declassify, also incidentally, would have belonged to any other president. So Trump didn't have some sort of special, unique power to classify or declassify, right? Any president would have had the power to classify or declassify. Of course, whether or not they did that is a whole nother set of issues. But let's press on. Anyways, carrying on. Right. Let's see. The FBI also developed evidence that more boxes contain classified information remaining at the residence. The department obtained grand jury subpoena directed to the plaintiff's custody of records and required all documents or writings in plaintiff's custody or control bearing classified markings. Plaintiff's counsel was served with a subpoena. Plaintiff sought and received an extension of time to produce the subpoenaed documents. After initially denying the request, the government extended the compliance deadline until June the 7th. On June the 3rd, in response to the subpoena, plaintiff's representatives produced an envelope containing 38 such documents. At the same time, his representative stated that he was authorized to certify a diligent search was conducted and that any and all responsive documents accompanied the certification. The envelope contained classified documents, including 17 marked top secret and was double wrapped in tape, consistent with handling procedures for classified documents. Plaintiff made no claims of privilege with the production of response, so he didn't claim that they were privileged at that time. Despite the production of documents in response to subpoena and counsel's response that diligent search had been conducted and all relevant documents had been produced, the FBI developed evidence that more classified documents remained. So they had some sort of reason to believe that despite the production of the documents to the National Archives, that more documents belonged at Mar-a-Lago. We don't quite know the reason for them believing that, because those portions of the affidavit were redacted, but they believed it and they found it, so I mean, it's at least something, so okay. In August, the department, through an FBI agent, informed a magistrate judge that it developed, and the magistrate judge agreed that probable cause existed of the evidence of possible violations of law. Based on the evidence, the magistrate judge issued a search warrant for residence. When the FBI executed the search warrant, it seized 33 items of evidence containing approximately 11,000 documents and 1,800 other items. Among the boxes, 13 contained documents with classification markings, and 3 classified documents were found in the plaintiff's desk. All told, the search uncovered over 100 documents marked as confidential, secret, or top secret. Okay. In accordance with protocol, the magistrate judge had approved the search warrant. The department directed a privilege review team. Okay, so this is pretty common. So one of the things you want to do is you want to determine if any of the documents might be privileged. So the Department of Justice often appoints a team that's to be separate from the criminal prosecution team or the investigation team. It's segregated off and supposed to review documents to determine whether or not there is any privileged material. Their ability to do this successfully is questionable at times, because sometimes they change their mind and sometimes documents are sent back to them for further review. And so the Department of Justice's ability to internally determine what is or is not privileged is, a little bit, okay, but that's one of the things they do. Is a privilege review team comprised of agents not otherwise participating in the investigation to review the certain documents to determine whether or not they were privileged, for example, attorney-client privilege. Based on review, the privilege review team identified and then separated a subset of about 520 pages, they note not documents, pages, that might contain privileged material. Within the remaining documents, members of the investigative team found at least 2 instances of potentially privileged material, which they delivered to the privilege review team. So right away, you can see the privilege review team might not necessarily have found everything, because the privilege review team did its thing and sent everything to the investigative team, and the investigative team said, hey, here are some documents that we think are privileged and we're sending them back to you for further consideration. So, unfortunately, not uncommon. 2 weeks after the execution of the search warrant, Donald Trump filed a motion in district court asking for the district court to appoint the special master, a neutral referee, to look at these documents, enjoin further review of the seized material until a special master was approved, require the United States to supply a more detailed receipt of property, and require the United States to return any item seized that was not within the scope of the search warrant. The United States made three primary arguments in opposition. First, the United States argued that Donald Trump lacked Fourth Amendment standing to seek relief because he did not have a possessory interest in the property. I mean, they were seized from his house, though, so normally that gives you enough standing. So I don't know about that. In support of its position, the United States asserted the records were presidential records, which belonged to the people of the United States and not to the plaintiff. Well, if they are presidential records, then yes, they belong to the people of the United States by law, but then, of course, whether they are presidential records or not is at least partially determinable by the president himself, as we learned through the case with Bill Clinton when tapes were found in his sock drawer. Seriously, that happened. And the Court of Appeals for the D.C. Circuit ruled that the president has the ability to determine what are and are not presidential records. Okay. Second, as to the appointment of the special master, the United States contended that the appointment of a special master is an exception, not the rule. This is true, although certain kinds of cases you see it more often. For example, when you have seizures of journalistic offices or seizures of lawyers' office, special masters are pretty much the rule, not the exception. So it depends on your kind of case. And then this, of course, in some ways is what in law we call sui generis, right? It's a self-generating case, right? Because there's not a lot of cases, as you might expect, with the seizure of records of the President of the United States. So it is not something that necessarily has precedent, nor is it something that fits comfortably into any precedent, right? This happens sometimes, not that often, but it does. And then you can say, okay, well, what is your rationale? So if you're looking for like a legal rationale for treating records or treating things a particular way, right? Precedent is your normal go-to, right? Why do you want to appoint a special master, for example? Why do you want to appoint a special master? It's like, precedent. The president of the United States is a newspaper, and we appoint special masters for newspapers. No, that doesn't work. He's not a newspaper. The president of the United States is an attorney's office, and we appoint special masters for attorney's offices. No, that doesn't work. He's not an attorney's office. So if you run out of precedent, right, you have one last argument. The argument of sui generis, right? This is a case that creates its own rationale. We should do it because we should do it. It's circular reasoning in law. But we gave it a fancy name called sui generis, self-generating. It's true because it's true. And then we moved on with our lives. Fantastic. Jennifer Fuller gives $5 to say, keep it up. Thank you very, very much for that kind super chat and sticker. I am pleased by the sticker. Thank you. Anyways, so the special master being the thing is an exception, not a rule, and the special master was neither necessary nor appropriate to address whether certain documents were subject to executive privilege because the plaintiff could not assert executive privilege against the executive branch, which, there is that latent issue, right? Can the ex-president assert an executive privilege, which, as the name implies, belongs to the executive, but he's not the executive. Biden is the executive. But can he nevertheless exert a privilege that would be past the current president? And even if he could, the privilege would yield to the United States' needs to investigate potential crimes and the United States' compelling interest in sensitive and highly classified documents. John O'Brien gives $2 to say the first rule of Tautology Club. You got it, baby. The first rule of Tautology Club is the first rule of Tautology Club. Yep, exactly. Appointment of a special master would be inconsistent with equitable principles, given that plaintiff has not, as required, turned records over to the archives in the first instance. So some of this is being driven by statute, and the Presidential Records Act does have a provision that allows for the ex-president to exert privilege by statutory right, which may or may not be valid in the first place because maybe it's unconstitutional, but, you know, those are fights for a different day. But you can't invoke the protection under the statute unless you follow the statute, which of course he didn't do. So there's all that. And the case did not involve complex or voluminous records. So a privilege filter team was appropriate. I don't know, man. 11,000 documents seems complex and voluminous to me, but that's just me. Third, as to injunctive relief, the United States argued that plaintiff had waited too long to seek relief. This was a big problem in the request. The timeliness of it was not great. And the department's review of the documents which plaintiff sought to avoid had already occurred. In other words, your request is moot. That we not look at the documents because we looked at the documents. Plaintiff was not likely to succeed on the merits of claims of executive privilege because he does not have any cognizable claim of executive privilege. Yeah, that's definitely going to be a fight that is going to go up and down the courts of appeal, I would imagine. I would imagine that if Donald Trump ever gets charged, we're going to go up and down the courts of appeal a couple times on this. And we'll have review by the Supreme Court a couple times as we try to deal with some of these issues. Because we're raising all kinds of interesting and fun, novel questions here, aren't we? The harm to the United States and its delay of investigation far outweighed any injury to plaintiff because of risk of national security. Malcolm Wellham gives $5 Canadian. Thank you. Says, always appreciate your streams. Thanks for explaining all this stuff. Also for what's worth, don't you think it's worth? Don't you think you're being biased at all? No, I'm trying to be as neutral as possible. I'm just trying to highlight the relevant legal issues. Like, here are the relevant legal issues, right? Here's what the ex-president is claiming. Here's what the Biden administration is claiming. Here's what the potential issues are. Here's a constitutional issue. Of course, there's this thing under the statute, but the statute itself may not be constitutional, and so forth and so on. I mean, I think I'm being pretty even-handed, but okay. Wish on a Fish gives 20 memberships to people in the chat. We do appreciate all of our uncivilians. And Pepe or POP 1976 gives 100 SEK to say of the executive, for the executive, by the executive, for Lincoln. Thank you very much. Yeah, I don't, yeah. And, you know, to say that I think that if it ever comes to trial, it will go up and down the courts of appeal and be heard by the U.S. Supreme Court a couple times, I don't think is speaking anything that isn't obvious. I mean, and then it raises potentially novel issues because of the potentially unique issues that are unresolved to someone at law. I think is not being, I don't know how much fairer I can be. Someone says I'm hurt. I do get a little bit hurt when people say I'm not being neutral because I try so hard. I try so hard to be fair and just be like, here are the issues. Here's what's in play. You know, here's the thing. Here's the things. Like, them being marked classified isn't the same as them being classified. I mean, that's obviously true. It's obviously not. It's obviously true. Okay, that we need that that if it ever comes to trial, that there's going to be going to appeal on some of these issues. It just seems obvious that it raises potentially unique concerns. I mean, the Supreme Court itself has language in some of its decisions that seems to suggest the possibility of privileges that might survive from one president to another. I mean, I'm not making this stuff up. There's just case law that seems to potentially read for these possibilities. So, he says I doesn't think I was being biased. Oh, okay, fine. For what it's worth, don't you think you're being biased? It says also, for what it's worth, don't think. It says, don't you think. It says, don't think you're being biased at all. Okay, I did misread it. You're right. I transposed 2 words and thus changed the meaning. Donnie Jomo says, it's Donnie to avoid the Tish thing. I like listening to you because I tend to be emotionally biased and you're so not showing any bias. You help me. Orange heart, cowboy hat. Well, thank you for the orange heart and cowboy hats. I do appreciate it. Thank you very much. All right. Plaintiff has replied that he has Fourth Amendment standing because the characterization of the documents, whether personal or presidential records, went to the merits of his claim, not the standing to raise it. While plaintiff appears to view appointment of a special master as predicate to filing a motion under Rule 41G, which allows a person to seek return of seized items, he's disclaimed reliance on that rule for the time being, saying he has not yet filed a Rule 41G motion, and so the standard for relief under the rule was not relevant to the issue of whether the court should appoint the special master. Fine. Alex Woodward gives $5 to say, I'm very liberal, probably one of the few in the chat, and I think you're being very even-handed. Thank you for your expertise and perspective. You're welcome. And Letitia from Tennessee says, so now there is a Tish thing, lol. I'm honored. Yeah. Well, you know, there might have been some pronunciation issues. The district court granted the motion in part. As to jurisdiction, the district court first concluded that it enjoyed equitable jurisdiction because plaintiff sought the return of property under Rule 41G, which creates a suit in equity. But, and then the district court deals with this by saying it's basically a hybrid motion, which, you know, fine. Because jurisdiction is equitable, it turned to the Ritchie factor to decide whether to exercise equitable jurisdiction. For the first of the Ritchie factor, callous disregard for plaintiff's rights, the district court found no evidence that the United States has engaged in this type of behavior. And to be fair, I don't think there is. I mean, they have behaved for better or worse as they would behave in a typical case. That may or may not be good, but it's true, right? Have they shown callous disregard? No, they kind of done what they normally would do. They did all the normal procedures, basically, versus a normal case. So, no, not callous disregard, that's for sure. Callous disregard, as you would expect, takes a fair amount. As the second amount, the interest in and need for seized property, the district court determined that plaintiff had an interest in at least some of the documents, like medical documents, tax correspondence, and accounting information. But it made no finding that plaintiff had a need for classified documents. The third factor the district court reasoned weighed in favor of exercising jurisdiction because, in its view, the plaintiff suffered a likelihood of irreparable injury in the form of improper disclosure of sensitive information to the public and threat of future prosecution and associated stigma. Now, as the Department of Justice notes, this concern is not different versus anyone else, but maybe the person is different, which gets us again into that wonderful idea of sui generis, right? Now, normally, to the extent a person being investigated by the Department of Justice, to the extent a search by the Department of Justice, to the extent a grand jury investigating someone, to the extent that charges against an individual would tend to harm someone's reputation in some way, it happens every day, right? So the one argument you could say was like, look, if the concern is the very investigation, the very search, the very potential charges in and of themselves are a harm, if you could raise that concern, everyone could raise that concern, and that would be dumb, right? And you can't help but say, you're right, that would be dumb. And so what is your refuge if you have to concede that it would be dumb for everybody else? It's different because of this particular person, which basically, incidentally, is what you would call an as-applied challenge, right? As opposed to being a facial challenge, right, where it's invalid against everyone, right, on its face, right? It's invalid against this particular person for particular reasons, right? Why? Why is it invalid against this particular person? What particular reasons? He's an ex-president. Why does that matter? Because it does. Sui generis. Right? That's your refuge. And it's not an inherently absurd argument, although of course you don't necessarily have to agree with it. But, you know, there are potentially obvious political implications of the highest order, because I don't think it would surprise anyone to argue that President Trump is likely to run for office. And if he does, likely to win the nomination and has a somewhat decent chance at potentially winning again, the Grover Cleveland of our age. And so perhaps him being, and also the fact that you have one administration criminally investigating a different administration does raise its own sui generis concerns. Because again, right? You don't have to agree with it, but let's just take note that this is something that does happen in third world nations. Does that necessarily imply it's improper here? No, it doesn't. But it does, if it doesn't make the hair stand up on your back of your hand a little bit, right? It's like, okay, well, one administration is investigating another administration criminally. Perhaps this is actually a political prosecution rather than a legal prosecution. To say that in the world history of the world, various governments investigating their predecessors have at times been political prosecutions, not legal prosecutions, is not exactly a contention without any merit, right? Is that what's happening here? Well, I don't know, but it could at least look like that. And so perhaps that concern is enough to give special concern, right? To make sure it's not what's happening here. So yeah, your sui generis argument can go a long way on these particular concerns, because, you know, there might be a need or desire for some additional safeguards because of these particularized concerns that wouldn't normally apply in your typical case. Potentially. Okay, the third factor, the district court weighed in favor of exercising jurisdiction because of the irreparable injury thing, because it's Donald Trump. Because it's Donald Trump basically is the argument, but we call it sui generis, so it sounds more fancy. And finally, the district court concluded that plaintiff has no alternative remedy at law because otherwise the United States might retain the property indefinitely. Based on the factors, the district court agreed to exercise equitable jurisdiction. And I think this is the best argument basically for the district court. It's like, it's just being really, really cautious, extraordinarily cautious, because, well, many reasons. There are some potentially unique legal issues that are in play that have potentially never come up before, because this has never really happened before. And so, you know, there might be a need for the judiciary to look over the shoulder of the executive with a little additional care to make sure that in this particular instance, everything is being done by the book. So, I mean, that's not a bad argument, actually, as far as it goes. And, you know, and also you don't necessarily know how some of those legal issues are going to ultimately fan out. Now, for what it's worth, I don't think that Donald Trump enjoys any executive privilege. So if you want a personal opinion, I don't think Donald Trump enjoys any executive privilege versus Biden, because I believe in the unitary executive theory, right? I believe that Article 2 of the Constitution says that the executive power shall be embedded in one president of the United States, because that's literally what it says. It says the executive power shall be embedded in the president of the United States, a guy. That's what it says, right? So the executive power, that is to say all of it, belongs to the executive without exception, necessarily. All of it. That's what we call the unitary executive theory, right? I believe in the unitary executive theory. Well, if Biden has all the executive power, that necessarily means that Donald Trump has none of it, or literally anyone else. So can Donald Trump employ executive privilege over the current executive? No, because I don't care what any statute says to the contrary, because it would necessarily be unconstitutional, because a statute can't defy the Constitution. Now, can it? If there's a statute, the Presidential Records Act, that says Donald Trump can invoke executive privilege, then it must be unconstitutional, because he can't, because all the executive power belongs to Biden, because that's what Article 2 says, damn it. So if you want a personal opinion, I don't think he can employ executive power. But then again, that's a personal opinion. And also, for what it's worth, perhaps ironically, unitary executive theory is much more widely accepted by conservatives and Republicans than Democrats, which is also mildly hilarious, which is also, incidentally, an interesting test of everyone's values, right? Because normally, right, if you are looking for people to support, now, it is, you know, normally, like if you're trying to make bold assumptions, bold characterizations, right, the people that are most likely to support unitary executive theory are the conservatives and the Republicans, because again, that's what seems to be what Article 2 says, right? So then you get to see how deep people's principles go, because maybe some of the conservatives say, maybe we don't believe in unitary executive theory, and suddenly maybe some of the progressives and Democrats say, we certainly do believe in unitary executive theory. It must all belong to Biden, nothing more. You know, we flip the narratives as is convenient, but not here on Uncivil Law. Damn it, we apply our principles consistently. Kathleen gives $9.99 to say love in your stream. Yeah. But of course, as a hypothetical trial judge, I don't know what the U.S. Supreme Court is going to do, so I'd probably be playing it cautious too. Because, again, as a judge, you can't necessarily always do what you think, because you have to, of course, apply the law. That's one of the reasons you wear the black robes, to adorn yourself with the facade of law incarnate, right? And a judge, as Scalia once said, a judge who always rules the way they think is not a good judge. Sometimes you have to rule against the way you think because it's what the law requires. So regardless of my opinion, personally, as vice trial judge, I'd probably be doing what this trial judge would be doing, even though I would think it would be wrong. Welcome to legal reasoning. It's, yeah, fun times. Anyways, next, the district court held that plaintiff had a Fourth Amendment standing to seek special master because he potentially has possessory interest in the records. The district court reached this determination because, as the court said, it was still undetermined whether the records were personal or presidential. Now, I take note here that, at least to my mind, again, right, personal versus presidential is one category, but governmental records are a separate record on themselves. Presidential records could be thought of as a subset of governmental records because they belong to the government, but I think it's slightly more helpful logically to think of them as a separate category, right? I mean, I think it's a little bit more helpful to think of presidential records as being separate and just being also owned by the government, but distinct from the governmental records, because I think it keeps the logic a little bit cleaner, right? And that way you have records which either are presidential or personal in one bucket, right? So on one side of the dividing line, so if you have all records potentially owned by the government, right? We can split it down the middle. On one side, we have a category of documents that themselves are either presidential or personal. And on the other side of the dividing line, we have governmental documents, which are neither presidential nor personal in my framework, because I think it's a little bit easier to separate. But that's me. $5 from Amber Rhodes. Thank you very, very much. And it might very well be the case, as the BioExplorer pointed out, that Trump has both, right? He could have documents that belong on both sides of the line, or documents from both sides of the line. So he could have documents that belong into the either presidential or personal heap, or the governmental heap. So, as to each document, you'd have to decide which side of that framework they go on. Anyways, carrying on. On the merits, the district court deemed a special master warranted, given the United States had found at least 2 instances in which a privilege review team reported the exposure of privileged material, which, yeah. And a special master might be perceived to be more impartial than the privilege review team. Yeah. Or at least it's a different set of eyes, which in and of itself is not bad, even if they are as fair as the privilege review team. Even if there's nothing wrong with the privilege review team, it is independent and thus furthers the interest of the perception of justice, which is also a goal, right? Justice must be done and seen to be done. So the privilege review team might have done justice, but to appoint someone independent would be to enhance the perception of justice, which might be a worthwhile goal unto itself. As to the executive privilege, the district court posited the plaintiff might be able to assert executive privilege against the current president. There is some language in the case law that might be read to suggest the possibility. And the court concluded the fact that the privilege review team hadn't screened for executive privilege further militated towards appointment because, again, from their own frame of reference, because they've been instructed by the current executive, they don't believe that there is such a concept as Trump having privilege that can usurp their own, because that wouldn't make sense, which from a constitutional perspective seems right, especially if you adopt the unitary executive theory. Go unitary executive theory. Finally, the district court enjoined the United States from further review and of the seized material from criminal investigation, but allowed reviewing materials for the purpose of intelligence classification and national security assessment. After the district court issued the order, the United States moved for partial stay of the order, pending appeal as to a limited set of documents, just over 100, that were marked as classified. The United States argued that plaintiff did not have an interest in the classified documents because they belonged to the United States, not him. And incidentally, whether they're classified or not wouldn't change the fact that they're governmental documents, right? So, right, even if Donald Trump waved the magic wand and made them non-classified, right, that wouldn't change whether they were governmental documents, right? And so he might be in improper possession, not of classified material, but he might be in improper possession of governmental material, right? Which is also incidentally illegal, right? If you have property of anybody and that person wants their property back, you have to give it back, right? Because it's not your property, right? If you have someone's car and they want their car back, you got to give their car back because it's their car, right? So are the documents classified or not is an independent legal question from who they belong to. And if they belong to the government, well, the government wants them back and you still have them. So you're in possession of someone else's property, so that's a problem, or at least potentially a problem, right? Okay. Such documents could not possibly contain attorney-client privileged information. If they're marked classified, that would be pretty hard. And even if plaintiff could exert executive privilege over some of the records, that privilege would be overcome by the United States demonstrating specific need to review classified documents to see if the risk of national security existed. I mean, fair enough. So, what are the limits of executive privilege if it exists at all? In this context, it is fun and exciting for the whole family. As to executive privilege, the United States has noted that Donald Trump has not exerted executive privilege in response to the subpoena. Instead, he produced documents and the custodian has certified it produced all responsive documents, which meant it could not assert executive privilege over documents that it was supposed to have already produced but did not. So one of the things that's in play here is, okay, Donald Trump has not, up to this point, made a formalized representation in the court process that the documents are, in fact, not classified. Now, from a criminal defense perspective, I think this makes total logical sense, because as a criminal defendant, you don't want to put yourself in a position before the United States government fully commits itself to its position, right? You ideally, as a criminal defendant, want to force the U.S. government to fully commit to its position. You want the prosecution to fully commit to its position before you commit to any position. Now, this is not necessarily always possible, but it is ideal, because if you as a defendant commit to a position, right, that position might be a problem once the United States government or whoever the prosecutor is commits to its position, right? If you say, for example, it was my property, and the United States government says, well, it's governmental records, and you say, but it was in my possession, right? Oh, it's my possession. I have the documents. They're in my possession. Okay, so you're in possession of governmental records? Wait, right? So it's like you don't want to necessarily commit before you understand what you're committing to, right? Because maybe you'd like to say they're not your documents. I've never seen those documents before, right? So I think Donald Trump is wise to not commit to a position at this time. He has not committed to a position as part of the formal legal process as to whether or not they were declassified or not, which, fair enough. But of course, all the district court can do is look at what they seem to be. And what they seem to be is classified. Maybe they are, maybe they're not. But Donald Trump isn't saying either way. So he is not asserting that in court, which is going to go a long way to the court basically throwing up its hands and saying, well, if you're not going to say they're not, I have to treat them as though they are, which is definitely probably what you want to do in this situation. But I mean, you have to pick your poison, and this is the better one. The United States argued it needed to stay of the district court's injunction against the investigation. The criminal investigation and national security were intertwined. The government emphasized, so the district court order prevented the United States from effectively reviewing the documents for the national security risk. In support of the proposition, the United States attached a document from the Assistant Director of Counterintelligence for the FBI. The declaration explained that since the 9/11 attacks, The FBI had integrated its intelligence and law enforcement functions when it exercises the national security mission. So we can't separate them out because we integrated them because of 9/11, which, if anyone knows anything about the history of how governmental agencies act, and before 9/11 with, everyone having their own little fiefdom and not sharing, and that being part of the problem that might have caused 9/11 in the first place, this is why the Department of Homeland Security was invented, because the children weren't playing nice with each other. And so the FBI says, we had a problem where these different divisions were separate and they weren't talking to each other. And this was kind of a problem because the children weren't playing nice, and we integrated them. And so we can't just wave our fingers and unintegrate them because we kind of designed it specifically to not do that. I feel that. The FBI says as part of its classification review to assess the damage to national security, the FBI needed to access the evidence and disseminate it to other intelligence agencies to assess potential harms. Those assessments would necessarily inform the FBI's criminal investigation. For example, if an intelligence agency were able to obtain intelligence indicating a classified document in the seized material might have been compromised, the FBI would be responsible for taking some of the necessary steps to evaluate the potential risk. Plus, the FBI attested that the FBI is the only intelligence community element with a full suite of authorities and tools to investigate and recover any improperly retained and stored classified information in the United States. Well, the FBI thinks they're they're the most important children in the intelligence community, which, okay. I mean, I suppose in some sense they are, because they're the ones with the power to arrest people. The CIA can't arrest people. The NSA can't arrest people. The geospatial people can't arrest people, and so forth and so on. The Defense Intelligence Agency can't arrest people. So is the FBI the most important child in the intelligence community? Well, the intelligence community can go fight amongst themselves over that one. We're the best. Not only that, but as a practical matter, the same senior Department of Justice and FBI officials, such as the person who's swearing this, are ultimately responsible for supervising the criminal investigation. So that would also be a problem, because I am the director of the counterintelligence and also would be reviewing the criminal investigation, and so I can't separate those roles because I'm both, and so that's a problem. The plaintiff responded that there still remains disagreement as to the classification status of the documents. He emphasized the special master review was temporary and asserted he had a statutory right to access the documents. And then we get into the wonderful issues of the statutory right versus the Constitution versus everything, and life gets complicated. On September the 15th, the district court denied a stay pending appeal and appointed the special master and explained the basis for decision. The district court first reasoned it was not prepared to accept without further review by the special master that approximately 100 documents isolated by the government were classified governmental records. Second, the district court declined to accept the United States' argument that it was impossible the plaintiff could assert privilege for some of the documents bearing classification markings. Again, there is some case law that might be read to suggest this, but of course, it is wonderfully unresolved. The next day, the United States moved for this court, that is the Court of Appeals, for the partial stay, seeking to stay the district court's order with respect to the 100 documents bearing classification markings. Now, personally, I think the district court probably should have said yes to this, but they didn't, so they're being overturned by the Court of Appeals. So, they are documents that are marked classified. They are almost certainly governmental records as opposed to presidential records. They can't be personal records, or at least they don't purport to be based on the classification markings. So this seems logical at this stage of the proceedings, right? Because of the level of certainty that we require. We've talked about this a little bit before, right? Especially in a criminal prosecution. Right? You need greater and greater levels of certainty as you move throughout the process, right? Ultimately, of course, you need proof beyond a reasonable doubt, but you don't need that at every stage of the process because that would be insane. You don't need proof beyond a reasonable doubt in order to open an investigation. You don't need proof beyond a reasonable doubt to have a search warrant, because that would be ridiculous, right? So you don't need that. So how much level of confidence do you need at every stage of proceedings, right? And basically, the further along in the proceedings that you get, the greater and greater levels of confidence that you ultimately require, ultimately getting up to proof beyond a reasonable doubt. So the question might be, for example, the question we might ask ourselves rhetorically is, okay, are these classified documents, right? All right, let's suppose we're going to charge Donald Trump with possession of classified documents, right? How much proof do we need ultimately? Proof beyond a reasonable doubt. What does that look like as a percentage? Well, different people give you different answers, but 95% plus, right? Somewhere above 95%. Yeah, it depends who you ask, 98, 99, somewhere along those kinds. That's the kind of frame we're working with, right? That's the question we ultimately have to ask. Okay, but we want to conduct a search. How much confidence do we need? Probable cause. All right, what does probable cause look like? 30%? Right, these are obviously numbers I'm pulling right out of my backside because these do not have percentage definitions. Very deliberately they don't, but these are the kind of numbers we're playing with. So at this time, are we 30% confident that they're classified? Sure, they're marked classified. And we've heard nothing to the contrary, so do I have 30% confidence they're classified? Yeah, that sounds right. And, you know, there's potentially legal issues in play that might change that, but, you know, 30%, that sounds about right. We're there, that's fine. So, you know, so we direct the plaintiff to file an expedited response for the partial stay. Donald Trump responded that we lack jurisdiction over appointing a special master. Really? Donald Trump, you argued that the Court of Appeals lacked jurisdiction? What? I'm almost tempted to go back and read that because I'm curious how that's even possible. How could you lack jurisdiction? It's the 11th Circuit Court of Appeals. That's the one that oversees Florida, where the district court is. So the district court has jurisdiction to appoint a special master, but the Court of Appeals doesn't have jurisdiction over it because I guess the argument would be because this isn't a proper interlocutory appeal. But, okay. But there was a stay in place. So you might not have jurisdiction over the appointment of the special master. That might be true. But you do have jurisdiction over the stay, right? Because the stay is an injunction. And injunctions are a proper subject of interlocutory appeal. So, okay, maybe that's what's going on. All right. That he has Rule 41G standing. The United States has not proved the documents marked classified are actually classified. No, they haven't, but at this stage, they don't need to, because we don't need to know that with beyond a reasonable doubt certainty. They're marked classified. So are they classified? Well, they're classified enough for the moment. I think that's what we can say. That's fine. And the district court properly balanced the harms. The United States has responded that the jurisdictional argument lacks merit. I mean, yeah. Plaintiff lacks 41G standing. The records bearing classification markings have no plausible case to privilege. And even if plaintiff has claimed to declassify them, the United States will still need to access them. Which, you know, fair enough. Maybe they're governmental records no matter what. And without the stay of the district court, and also we don't know that he's declassified them because, again, reminder, in court proceedings, he hasn't claimed that yet. All Donald Trump has said in formalized proceedings is that there's a dispute over whether there's classified or not. He has not actually said at any stage formally that he's declassified. He simply said it's up in the air. We don't know whether they're classified or not. Okay. So, yeah, I mean, that's not going to cut it at this stage. We've carefully reviewed the parties' brief and the records. And Thelia says, can someone tell Kurt he should interact? I interact from time to time. And I do appreciate everyone who is kind enough to give me super chats and otherwise support the channel. You know, so I will induce my my friends to help support the channel, and that will definitely spur some interaction. So we have appellate jurisdiction over the courts with respect to interlocutory appeals granting injunctions. I mean, yeah. So the appointment of the special master, no. The injunction, yeah. I mean, that's fair enough. When deciding whether to grant an appeal, we evaluate 4 factors. Whether the stay the applicant has made has a strong showing his likelihood to succeed, whether it be irreparably harmed, whether the issuance of the stay will substantially injure the other party, and whether it's in the public interest. This is the 4-part standard for injunctions. We know it. We love it. is the way that we do things. The United States argues the district court likely erred in exercising jurisdiction to enjoin, which is to prevent, the United States use of classified records, and to require the United States to submit the documents to the special master. We agree. Our binding precedent states that when a person seeks return of seized property in pre-indictment cases, those actions are governed by equitable principles, whether viewed as based on 41G or general equitable jurisdiction. So no matter how you slice it, this is an equitable question. Here, while plaintiff has disclaimed the motion was 41G, they asserted equitable jurisdiction. And the district court relied on both 41G and equitable jurisdiction. Either way, the case law teaches us that equity controls. So does 41G apply or not? Doesn't really matter. Either way, we're going to apply equitable considerations. Whether a court should exercise equitable jurisdiction in this context is subject to sound discretion of the district court, but discretion, of course, as always, is not boundless. The factors the court should consider to determine whether to exercise jurisdiction include whether the government displayed a callous disregard for constitutional rights, which, no. Whether the plaintiff has an individual interest in need for the material which he seeks, as the classified documents, no. Whether the plaintiff will be irreparably injured by denial of the return of the property, as to the classified documents, no. And whether the plaintiff has an adequate remedy at law for redress of his grievance. We begin as district court did with callous disregard, which is a foremost consideration in determining whether the court should exercise equitable jurisdiction. Like, okay, so just as a kind reminder, right? Law and equity are separate concepts, right? They are different things in law and equity. And so this is equitable, which means by definition, you're never entitled to it as a matter of right, right? You're only entitled to it if the need warrants it, I suppose, in some ways. And whether or not there was callous disregard is our foremost consideration. Our precedent emphasizes that the indispensability of alleged callous disregard. Here, the district court concluded there was no showing of callous disregard. No party contests the finding. The absence of the indispensable factor is reason enough. I mean, that would mean what it would mean to be indispensable, right? I mean, that's just words. That's how words work. It's kind of what indispensable means. We can't dispense of it. So you don't have it, so that's kind of a problem. So, yeah. The second factor considers whether the plaintiff has an individual interest and need for the material. The district court concluded that plaintiff has some interest in the material because it includes medical documents, correspondence related taxes, and information for accounting. But none of those considerations apply to the classified documents. Yeah. And the district court made no mention in its analysis of a factor as to why or how plaintiff might have an individual interest or need in classified documents. That would be pretty hard. I'm not sure under what circumstances, if any, a person could have an individualized interest in classified documents. That would be pretty difficult. For our part, we cannot discern why plaintiff would have an interest in or need for any of the 100 documents with classification markings. Classified documents are marked to show they're classified, for instance, with the classification level. They are owned by, produced by, or under the control of the United States government. And they include information, the unauthorized disclosure of which could reasonably be expected to cause identifiable harm or describable damage to national security. For this reason, a person may have access to classified information only if, among other requirements, there's a need to know. This requirement pertains equally to former presidents unless the current administration, in its discretion, chooses to waive that requirement, which, they not so much with Donald Trump because they don't like him. Plaintiff has not even attempted to show he has a need for the information contained, nor has it established the current administration has waived the requirement. They most certainly have not. And even if he had, that in and of itself would not explain why he has an individualized interest in the documents. Plaintiff suggests that he may have declassified these documents, but he hasn't. He suggested. He hasn't stated. But the record, of course, contains no evidence that they were declassified. They didn't go through a formalized process, that's for sure. Right? Donald Trump may or may not have spoken the magic words, but they didn't go through a formalized process, so we don't know. And even before the special master, plaintiff has resisted providing any evidence he's declassifying. He's refused to say, which again, I think is probably the better position at this stage. Right? That is the better position right now. I don't think you want to take a position on that either way right now. You want to force the United States government into a position before you decide what position you want to take. All right. In any event, at least for these purposes, the declassification argument is a red herring because declassifying an official document would not change its content or render it personal. That is the key, right? That is the thing. So maybe Donald Trump can't be convicted under the Espionage Act because maybe Donald Trump has not mishandled classified material because maybe they're not classified. I don't know. Maybe not. But regardless of whether they're classified or not, that is not the end of the analysis, right? Because it could be, well, it wasn't that it's classified, it's that you had improper access and improperly retained governmental records, whether classified or not. So it is a bit of a red herring because them being classified or not certainly doesn't change them into personal records, right? It would just change their classification status. A governmental record, classified, does not become a personal record once unclassified. That doesn't make any sense. So even if we assume that Donald Trump did declassify some or all, that would not explain his personal interest. This factor also weighs against exercising jurisdiction. Third, we ask whether Donald Trump would be irreparably injured. The district court identified potential harm that could arise based on improper disclosure of sensitive information to the public, the United States retention and use of privileged material, and stigma associated with future prosecution. We cannot conclude the plaintiff will be irreparably injured by its day regarding documents marked classified. The plaintiff suggests he could be harmed by disclosure of sensitive information, but permitting the United States to retain the documents does not suggest they will be released, which, to be fair, is a bit speculative. In fact, right, the United States government is incentivized to not release them because they're classified. So just because the United States government is reviewing them does not suggest they will ever become exposed. It's one of the factors that the Department of Justice will have to consider as it decides whether or not to prosecute, right? Especially if it wants to prosecute for them being classified, as opposed to being them governmental records, right? It might, at some stage, have to produce the documents to a jury, for example. And so that information would become exposed, at least to the jury. And so, just because the United States is reviewing them does not suggest they'll be released. Fair. Indeed, the purpose of the United States' effort to investigate the documents is to limit unauthorized disclosure. Not only that, but any authorized official who makes an improper disclosure risks criminal liability. Yeah. Now, of course, the president is different, but then again, we have to get into what Donald Trump did or did not do while he was president and so forth and so on. But yeah, they're not going to just willy-nilly expose it because that would be a problem. We also doubt the plaintiff risked irreparable injury in the form of disclosure of privileged information because there's not been an assertion of attorney-client privilege over the classified documents, which I'm not even sure how that would hypothetically occur. But, not so much. OG Boxer says too many secrets. When did we bring C-Tech astronomy into this? The remaining potential injury identified by the district court is the threat of future prosecutions and serious, often indelible stigma associated therewith. No doubt the threat of prosecution can weigh heavily on the mind of someone under investigation. But without diminishing the seriousness of that burden, if the mere threat of prosecution were allowed to constitute irreparable harm, every potential defendant could point to the same harm and invoke equitable powers. Now, this is the weakest part of the analysis, because Donald Trump is different, though, actually kind of goes a long way, in my humble opinion. Now, that doesn't mean that I think the district court is wrong. The Court of Appeals is wrong. I don't think they're wrong. I think they're right. I'm just saying that this part of the analysis is a little weak. I think they're ultimately right, though. But, I think there's a little bit weak here, because Donald Trump is different, though, Because, again, the fact that you have one political administration criminally investigating a former political administration, again, should raise a few alarm bells. Again, not to say it's improper, not to say it's wrong, but it should make you a little bit squirrely when you have one administration investigating another administration, because, well, the potential for abuse is unbelievable. And the concerns from the annals of history are legendary. So it's Donald Trump, though, actually goes kind of a far way. So I think this analysis of this part is a little weak. Is a familiar rule, and the courts of equity do not ordinarily restrain criminal prosecutions. True. But of course, this is maybe different. In sum, the third factor also weighs against exercise. I'm not so sure about that, but okay. Finally, the court asked whether the plaintiff has adequate remedy at law for a grievance. The district court found this factor weighed in favor of the plaintiff because otherwise they'd have no legal means of seeking return of his property for the time being. But plaintiff has been clear he's not seeking return of the classified documents. And if he were, he has not identified any reason that he'd be entitled. So not so much there. So I'll agree with the Court of Appeals on 3 out of 4 factors, which is more than enough to sustain their overall reasoning on further review by the true Court of Appeals, which is me. In sum, none of the factors favor exercise equitable jurisdiction. Consequently, the United States is substantially likely to succeed in showing the district court abused discretion in exercising jurisdiction over the motions as it considers the classified documents. I mean, I tend to agree on all that, to be sure. We next consider the second factor, whether the United States would suffer irreparable injury. The motion for partial stay distinguishes the roughly 100 seized records with classification markings from remaining materials. Those documents are special because of their markings. I mean, fair enough. Because the classified nature of the documents bears our analysis, we begin briefly with an overview of the United States system of classification. Oh joy, let's do a history lesson. Since World War I, the executive branch has engaged in efforts to protect national security by means of a classification system graded according to national sensitivity, and cites Department of Navy versus Egan, which has some wonderfully interesting things to say about executive privilege, which is definitely relevant to this case. In practice, presidents have often used executive orders to protect sensitive information, among other things, by the way, because we've discussed Navy versus Egan. Among other things, Navy versus Egan, among other things, stands for the proposition that the President of the United States has total and absolute authority to do anything he wants at any time, and he doesn't have to follow any procedures, and he cannot be questioned because he's God when it comes to classification, which might be true. It's called a plenary power, or God. So yeah, but of course, then again, that would extend to the President of the United States, which at this time at least is not Donald Trump. So yeah, it's not illegal when the president does it. It's not a wholly invalid argument, in other words. In practice, presidents have often used executive orders to protect sensitive information and ensure proper classification throughout the executive branch. The current operative classification protocols are described in Executive Order 13,552, or 56. Those are the standard protocols. Under the executive order, there are 3 levels of classification: confidential, secret, and top secret. The standard for level at which particular information should be classified turns upon whether the disclosure of the information could reasonably be caused to cause either damage, serious damage, or exceptionally grave damage to national security. Once so designated, classified materials remain classified for up to 10 years unless the original classifying authority determines the direct duration should extend for up to 25 years. So, and again, this doesn't really necessarily speak to the legal issues in play, but there has been much criticism, again, historically, more from the left than the right, but there has been much criticism that there is overclassification of materials, and that more materials is swept up than not. but that doesn't necessarily change their classification status, but it is a note that just because it is marked as being exceptionally gravely damaging in the United States does not necessarily make it so. Sometimes they overclassify. The executive order also sets forth how documents can be declassified. If you're following the procedure, yes. In general, information can be declassified or downgraded by the official who has authorized the original classification, his successor, her supervisor, or other official with express declassification authority. Classification records are also subject to automatically classifying if they've been more than 25 years old and have permanent historical value unless they fall into certain enumerated categories that could cause harm to national security. So it's 25 years unless it's not, which, doesn't really help you that much. For example, information that could reveal the identity of confidential human source or relates to a weapon of mass destruction is exempt from automatic disclosure. Well, that's probably a good policy. Returning to the case before us, under the terms of the district court's injunction, the Office of the Director of the National Intelligence is permitted to continue its classification review to assess potential risks to national security. But the United States is enjoined from further review and use of the materials for the criminal investigation purpose. The Court of Appeals notes the distinction is untenable. Through the FBI's declaration, the United States has sufficiently explained how and why it's inexorably intertwined because of 9/11, which makes total logical sense. Because after 9/11, we, wanted the children to play nice because there used to be the fiefdoms, and the fiefdoms was a problem. So they're intertwined now, and we can't just undo that. The ingrained principle that courts must exercise traditional reluctance to intrude upon the authority of the executive and military and national security guides a review. That too, right? When it comes to the national security, the courts are historically and often properly deferential to the executive branch, which, fair enough. The judicial branch is not necessarily in a great position to evaluate such things. So the executive branch the judicial branch has historically been reluctant at very best. No party has offered anything beyond speculation to undermine the United States representation. The findings for criminal investigation may be crucial to national security. Accordingly to the United States, a criminal investigation will seek to determine, among other things, the identity of anyone who might have had access to the materials, whether any particular materials were compromised, and whether any additional materials may be unaccounted for. As Donald Trump acknowledges, backward-looking inquiries are the domain of the criminal investigation. Yeah. It would be difficult, if not impossible, for the United States to answer these critical questions if its criminal investigators are not permitted to review. I mean, fair enough. It is too important to segregate off, and whatever value Donald Trump has is minimal to non-existent. His interest in the documents, in order to stop the United States government from reviewing them, right? And of course, it should go without saying, but right, the ability of the United States government to review them, the ability of the United States government to use them in a grand jury, the ability of the United States government to use them as part of an indictment, the ability of the United States government to use them at a trial, the United States government's ability to use them to convict, right, are all potentially separate legal questions, right? Just because we're saying you can review them does not necessarily imply any of those things down the road, which will have to be analyzed as things emerge. So, yeah. I feel for the district judge if someone brings a criminal case against Donald Trump. That's just gotta be like the worst. Because this is so sensitive. I mean, that's a rough go, man. You gotta put on your big boy cowboy hat for that one. Precisely because the United States criminal investigations focus on past events, Donald Trump responds the United States is not irreparably harmed because it can be distinguished from a prospective national security view. We're not persuaded. The United States explains there are circumstances where national security assessment is inexorably intertwined with the criminal investigation. Plaintiff acknowledges the two may relate, but contends that any tension between these functions can be resolved because the district court order permits national security assessments that truly are, in fact, inexorable from criminal investigation's use of seized material. But of course, determining whether it's truly inexorable is far more easily said than done. The problem, of course, is that you kind of have to run to the end of the page, which you don't normally do in the first instance, right? You normally, Under the theory, officials charged with overseeing both national security and criminal investigations would risk contempt of court, ultimately chilling their national security duties. Thus, an injunction denying or preventing the United States criminal investigation from using the materials imposes a real and significant harm on the United States. The United States also argues that allowing the special master and plaintiff counsel to examine the classified records would separately impose harm. We agree. The Supreme Court has recognized for reasons too obvious to call for enlarged discussion, the protection of classified information must be committed to the broad discretion of the agency responsible, and this must include broad discretion to determine who may have access to it. Now, again, if you wanted to determine anyone should have access to it, the person they picked as a special master is a pretty good choice, but still. As a result, the court should ordinarily review such materials only in the most extraordinary of circumstances. The record does not allow for conclusion that this is such a circumstance. I mean, I tend to agree. I tend to agree. There's not enough here based on the vagaries at this point, which again are completely appropriate at this stage, in my opinion. The vagaries are appropriate for Donald Trump because he's not committing to a position, which he shouldn't. It's in his interest not to commit to a position. He should make the DOJ commit as much as he can, and he should commit as little as he can. But of course, because he's not committing to a position and everything is just kind of speculation and wishes and sort of fluff in the wind, it's not persuasive. But you don't want it to be persuasive now. You want to reserve that for later when it really matters, right? When it might be used at trial, when you really have to bring that once you know everything that is going to be brought. In sum, given long recognized compelling interest in protecting the secrecy of the important information in national security, we conclude the United States will be harmed from the restrictions on this narrow and potentially critical set of materials that would require the United States to submit it to the special master. Fair enough, says I. We next turn to the third factor, whether issuance of the stay will substantially injure other parties interested in the proceeding. We analyze where the plaintiff would be substantially injured by a stay, largely for reasons we've discussed, not so much. First, as we've explained, the plaintiff does not have possessory interest in the documents at issue, so he does not suffer a cognizable harm if the United States reviews them. Second, we are unpersuaded Donald Trump's insistence that he be harmed by a criminal investigation. Bearing the discomfort and cost of prosecution for crimes even by an innocent person is one of the painful obligations of citizenship. Now, again, generally true, but there are some unique concerns here that are being a little bit blown by, right? So we can say that this part of the opinion is a little weak. This is not, I think, your ordinary criminal case. There are some issues here that bear some special and unique analysis for some very important concerns, among which is to make sure this truly is a criminal prosecution and not a political prosecution, which, yeah. Third, B. Locke says DOJ has the burden of proof. Are documents classified? No. POTUS can declassify anything. They have nothing. Yes. Well, whether or not he can declassify anything and whether or not he did declassify anything are, of course, two separate issues. And what we can say definitively is Donald Trump did not go through the process set out forth in the executive order, which is not to say that he has to, but he didn't. It's also to say that the markings on the documents have not been changed. So at this stage of the proceedings, if you're the court, right, and you're trying to make a decision based on the standards that apply and the level of confidence you need to have at this stage of proceedings, right, which is probably probable cause, which is like 30% certainty. It's like, well, do you have 30% confidence that they're classified? It's like, yeah, because they're marked that way. So you have your prima facie case, right? That isn't the same as them being classified, but they're marked classified. On their face, they're classified. Literally on their face, they're classified, right? So are they classified? I don't know, but we don't need to make that determination yet. So we have enough confidence to proceed at this stage if we're applying the relevant legal standards at the right level of confidence, given the level of stage of the criminal prosecution that we're at. Third, because the nature of classified materials is at issue here and based on the record, we have no reason to expect the United States use of the record imposes the risk of disclosure. Given limited scope of the stay, we conclude the plaintiff has not shown he'll be irreparably harmed. And the Psycho one does point out quite correctly that if Donald Trump becomes president again, he will be able to pardon himself. And these are all, of course, federal crimes. I agree that the President of the United States has authority to pardon himself because the power to pardon is in the Constitution unqualified. And so, yes, at least as far as I'm concerned, the president can in fact pardon himself. And so, and at least my view of such things, right, I don't think that even being convicted of any of the statutes at play can prevent the President of the United States, apologize, let me rephrase, I don't think conviction of any of the statutes in play can prevent Donald Trump from running and winning as president. Now, various statutes that are in play do say that conviction disqualifies you from holding office, but I think those provisions are unconstitutional. I think they're unconstitutional, at least in part, informed by a case called U.S. Term Limits versus Thornton, which tried to impose term limits on members of Congress. And the United States Supreme Court, in striking down the term limits that were attempted to be imposed, said that the only requirements are imposed by the Constitution itself, and that no additional requirements can be imposed. So, for example, to be a member of the House, you need to be 25. You have to be a resident of the district. You have to be a citizen. You have to be a resident of the district, and you have to have lived in the United States for, I believe, 5 years, if memory serves correctly. But I'd have to double check, but those are the requirements and nothing more. So the Congress or no state can impose the additional requirement of, oh yeah, by the way, the term limit thing. Well, if you can't impose additional requirements on a member of Congress, surely you can't impose additional requirements on the President of the United States. And of course, the only requirements to be President of the United States are again spelled out in the Constitution, which include being 35, being a natural born citizen of the United States, and being a resident of the United States for 14 years, which Donald Trump is all of those things. And so I don't think that even if he's convicted, he can be prevented from running for the United States president, because despite this language of the statutes to the contrary, I think it's unconstitutional, and then he can pardon himself and everything just gets really fun and interesting. But that is for another source for another day. And yeah, the POP says there might be practical problems in each state if they allow him to be on the ballot. Yes, but in part, we've already dealt with the practical problems, right? Because, for example, the great state of California put a requirement in place that in order to be placed on the ballot for President of the United States, you had to give over your tax information. Seriously, they made a requirement that said, in order for you to be placed on the ballot, you must give your tax information. Donald Trump, of course, did not. Donald Trump sued. Donald Trump won. He was on the ballot in California in 2016. Because why? U.S. Term Limits versus Thornton, it's an additional requirement, not imposed by the Constitution. Nothing in the Constitution says you have to give over your tax record, so it cannot be imposed by the state. So we've already dealt with these practical problems before, and we will again. No problem, rinse, repeat. It's all fun. We now come to the fourth factor where the public interest lies. The documents of interest contain information, the unauthorized disclosure of which could reasonably be caused to expect to cause exceptionally grave damage to the United States. I mean, that's what they're supposed to be. It's self-evident the public has a strong interest in ensuring the storage of classified records did not result in exceptionally grave damage. Ascertaining that necessarily involves reviewing the documents, determining who has access to them and when, and deciding which, if any, sources are compromised. For these reasons, we conclude the public interest favors the stay. And for these reasons, we grant the stay. And I agree. Although I found various parts of the document to be weak, as we discussed, I do agree with the overall thrust of the decision. So I would sign off on this decision. I might note my disagreement with, it's like, well, Judge Mueller agrees, except as to section like 36A or whatever it was, right? So I might note my disagreement with those particular sections, but overall, I tend to agree with the analysis that this makes a lot of logical sense, given the standards that are in play. At this stage, it makes a lot of sense, which of course I've gone out of my way to try to point out. That does not necessarily imply what will be true for any other stage. It certainly does not imply they can or should be used at trial, and so forth and so on. But one issue at a time, damn it. It's the issue that we're at, right? Danielle Winterton gives $4.99, says, in a two-party system, who can ethically investigate the ex-president's potential crimes if their own party won't, and it's unethical for the own party too? I didn't say it was per se unethical. I just said it raises particular concerns, right? I think I went out of my way, and I'll say so again, right? I didn't say it's per se unethical. I didn't say it was per se wrong. I didn't say that what the Biden administration doing is inherently wrong or shouldn't be done. I'm simply saying that it raises particular specters that are worthy of special consideration and special safeguards because of specialized concerns, right? Everything here might be well above board. Maybe everything here is quite proper, right? And then, of course, we also get into quite proper on its face versus proper in reality. So we could at least hypothetically distinguish on this being a just criminal prosecution by the letter of the law versus the reason we're prosecuting in the first place being we're targeting this particular individual, which again raises its own special concerns, right? But I've at no point suggested that this is inherently improper. I have suggested, as far as I've reached any conclusion, that the appointment of special master makes a lot of sense to my mind because it's an additional safeguard that should be put in place, at least in my opinion, to help ensure the perception of justice because of the specialized concerns. So hopefully that analyzes all that. And Cherry and Max gives $10 to say, thoughts on where this all might go. P.S. The plan you came up with for weeks ago for a show are a success in my book. Excellent. I'm very happy that you say that. Thank you. I'm trying to make things better and better every passing day, and I appreciate your support. So where do I think this is going? I think this is coming to an indictment. I think that's where this is going. And I think that the indictment will be dropped at what seems like the most politically convenient time. I think that the indictment will probably drop, and which also raises concerns, but I think that it'll probably drop sometime closer to the primaries or general election than, for example, now. I think they'll want to reserve that. So I would expect things to pop off in maybe a year. But I could be wrong, but that's what I would expect. I don't think it's going to happen tomorrow. Well, maybe it will happen tomorrow. But I think, it's like, yeah. In your opinion, can the president declassify documents by thinking it? No, I don't think so. I think you have to do something to manifest the intent. I think you have to say it. I don't think you can merely think it in your own mind. I don't think that quite makes sense. That's a bridge too far. I think you can do it by speaking the words into existence, but I don't think you can do it merely by thinking it, because that doesn't even really make sense. Because how would you know that he really thought it? Among other problems. Assuming that he could do it, assuming that he could declassify by thinking it, the only way to get that information would be for Donald Trump himself to testify, because he's the only person that could testify as to his own thoughts. It would necessarily require him to take the stand as an affirmative defense, right? So, assuming assuming the President of the United States can declassify merely by thinking, and assuming Donald Trump did declassify merely by thinking, right? The prima facie is that the documents are classified because they're marked classified. So the government makes its prima facie case. So the only way to get evidence of Donald Trump's own subjective thoughts, because again, we're assuming he didn't tell anyone or write anything down. The only way to get evidence as to his own subjective thoughts would be for Donald Trump to take the stand, which means that he waives his Fifth Amendment privilege and would be the most intense cross-examination in the history of time. It would go on forever. It would go on forever. The transcripts would be legendary. Yeah, so assuming it's possible, which I don't think it is, I think the president has to do something. A thing. Anything would be fine. He can speak it into existence. He can write it down. He can put it. He can put it on a post-it note. But he has to do a thing. Tell an aide, whatever. Tweet even, right? Because there's been suggestions that he just declassified via Twitter. Now, of course, the White House at the time said that the tweets weren't self-executing. But then again, well, maybe they were, despite what the White House said, right? Because, I mean, Donald Trump did tweet things that could be read as saying he did declassify, and the White House said, well, that's not what they mean, but maybe it is what they mean. Maybe he did. Maybe the tweets are declassifying. I don't know. All kinds of legal questions at times. All kinds of fun. POP 1976 gives SEK 50 to say, wouldn't any time for indictment of a former president be close to a primary or election? Well, it depends on your frame of reference, but I suppose that, you know, if they drop it like immediately following the midterms, if they drop it in like January, then it would be, you know, as far away from that as possible. But your point is noted, because we do have a 2-year election cycle. So your point is noted. Colin gives $4.99 to give me a sticker that says it is a picture of a fox with a paintbrush painting a sign that says number 1. I'm number 1. Aw, thank you. And Batman's Pet Goldfish gives $2. It says, is taking the documents evidence of declassification? Well, I don't know. That maybe it's an argument. Maybe that's declassification. By moving the documents. Well, the thing is, it's a little bit tricky because he moved them to Mar-a-Lago when he was still president. And of course, the president of the United States can kind of take declassified documents with him anytime. So, but does putting them in his personal residence indicate an intent to declassify? Well, these are some of the arguments that might manifest at some point in the future. But I think let's just say that Donald Trump is in a better position the more solid his method of declassification is. Although the Department of Justice might circumvent the issue completely and just not charge him with possession of classified documents, right? They're investigating the Espionage Act, which would deal with the classification of documents. But the Department of Justice can just circumvent the entire issue and save themselves a headache by not charging him with anything. And they don't have to. They can charge him with violations of governmental property instead, which seems like a weak-ass charge, like you were in possession of our property and didn't give it back, which is kind of like not the strongest charge I've ever heard in my life. But, you know, they can save themselves the headache by not raising the issue. So we'll see. Maybe they won't even raise the issue and we'll never have to get into it. KWH gives $2. Thank you very much, KWH, for your kind super chat. Can we get my 18th Amendment videos in a separate video? Maybe I'll excise that and upload it separately. I mean, it is a video. So yeah, I could do that. Maybe I'll do that. Maybe I'll excise the thing from yesterday and put it in somewhere. Okay. Well, my friends, that brings us to the end of this discussion of this 11th Circuit ruling. And I hope you found this informative and legally interesting. And I hope I was able to teach you something about some of the issues that are in play. Constitutional law analysis, statutory law analysis, presidential records, governmental records, declassifying authority, different stages of prosecution, different stages of review, different standards, equitable jurisdiction, all kinds of stuff that we had. We had a very extensive legal discussion. and a lot of highlights of potential legal questions to which no one quite knows the answer to. No one's been forced to answer them before. It's like, can a former president claim some sort of privilege that somehow beats the current president? And it's like, well, I think the answer is probably no, but there's some suggestion from the Supreme Court. Maybe it's yes, and we'll have to get into it. But I hope you enjoyed this very stuff. Some of my recent videos end very abruptly. That's a little bit by design. Denna Hall. Some of my videos end abruptly. That is by design. I have been watching many videos on how to make your YouTube videos better and more interesting. And one of the overwhelming things I have heard is that if you're interested in improving your watch retention time, right? If you're interested in making sure that people watch all the way to the end of the video, one of the very worst things you can do is signal explicitly that the video is coming to an end, because people have a tendency of clicking off, right? So I used to have that outro where I had the whole thing with thank you very much for watching this. If you enjoy, like, I used to have the outro. The problem is, of course, that the analytics say that a lot of people click off, and so it hurts overall watch time. It hurts overall retention time. So therefore, what can you do? Well, you don't make it explicit that the video is ending, right? You just end it, and that way they watch the entire video. So that is not to say that I'm doing it perfectly. That is not to say there's a better way to do it, but it is to say that the video is just ending without it being noted that they're ending is quite deliberate, because I've been watching videos on how to improve watch time and stuff like that on try to do. Yeah, see there, Ellie, there I go reading and researching again, right? There I go reading and researching, like, how do I do this, right? So all those good things. Anyways, I'm gonna sign off for now. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.